Hi, it's Bill Cottrell again from Cottrell Law Firm, hosting Law Talk. And the purpose of this show is to provide people in the Eagan-Burnsville community with information about various areas of law. Today I'm happy to be hosting a solo attorney named Ellie Vilendrer, who offices in Minneapolis and Beverly Hills, and we're going to be talking about business law as well as entrepreneurship. Nice to meet you, Ellie.
Thank you, Bill. Thanks for having me on the show today.
It's my pleasure. Before we get started, can you tell us a little bit about your background in the law and what kind of law you practice?
Yeah, I'd be happy to. So I started my law practice in California, practicing all different kinds of civil litigation and business litigation. I then moved to Minnesota. I joined a firm out here. I continued to practice in civil and business litigation. And then a few years ago, I left to start my own practice, and I focused my practice on corporate transactional law with a special niche focus in helping folks resolve their disputes outside of court, and that focus is on businesses.
And are you licensed in both California and Minnesota?
I am.
And how do you like being on your own? Tell us about that.
I love it. Having your own business is tremendously rewarding. It's a lot of hard work because you have to wear many hats. You're not just doing the function of a lawyer, but you have to think like a business person and run a business. But it is tremendously rewarding.
Well, speaking of starting a business, let's say that you were retained by a small business who wanted to get started. What would be some of the things you'd discuss?
Bill, that's a great question. Entrepreneurs really have to wear a lot of different hats. And so I would sit down with my client and I would ask them what their vision is for this business. So is this a business that is going to be owned by just one person? Or is this a business that's going to have multiple owners? Is it a business in which you plan to hire employees or independent contractors and really try to scale your company and leverage the time of other people? Or is this, again, just going to be you doing what you do really well? And so we need to talk with the client about their fundraising plans, if they need to raise funds, or if this is going to be self-funded. Because, if someone has this grand idea that they want to take this company public, or raise substantial money from venture capitalists, for example, we really have to structure it in a different way than just a person who wants to, start their own small business. So the structure of the business, the entity type, is one thing we really need to discuss and think through. If there's going to be multiple owners, then you have to think about agreements between the owners, like an operating agreement or buy-sell agreement. While the owners are still cooperative and friendly and able to negotiate those terms, that's really when you want to get that in writing. And if you're going to have employees, a very important concern is not to misclassify those employees as independent contractors. So an independent contractor is an independent contractor by virtue of you calling them an independent contractor, or by virtue even of them agreeing to be called an independent contractor. There's really criteria that has to be met. And really what's extremely important, and this is from the business side, is what is your competitive advantage? And from the legal side, how are you going to protect it? If you indeed have a good idea, what is going to stop others from copying you?
Exactly.
And so when we think about those legal protections, we think about patents. So if this is a tech company and you have proprietary technology, you want to file a patent to try to protect it. Trademarks are extremely valuable. So in the intellectual property realm, we're thinking trademark applications. You think about confidentiality agreements, non-compete agreements, IP assignment agreements. If you have a secret sauce, you want to protect that, you want to make sure you're protecting it as a trade secret. So there's really a lot of different things to think about, and I tell my clients, now is the time to make your plan. You do want to see way out into the future. I do want to know, is this a company that you plan to sell fairly quickly? Is it a company you want to ride out until you retire? Is it a company you want to take public? And then we talk about their plan, and we talk about bringing in the appropriate professionals with, or the appropriate experts to come in and help guide us in the different areas.
Well, I represented a few small businesses, and one of the things that becomes an issue right away is what you earlier mentioned. That's the ownership of the company, and buy-sell agreements and investor agreements. And sometimes you have to be careful as an attorney. You can't give advice to people who have competing interests, and maybe you could tell us how you handle that situation.
Yeah, that's true. You can't have a conflict of interest, and those can arise. And so, if you're representing the company, that's one thing. If you're representing an individual, that's an entirely different thing. And individuals do have different interests, especially when it comes to buy-sell agreements or operating agreements. And if you're dealing with owners that have different ownership percentages, it really becomes an issue. So if it's 50-50, it's one thing. If you have an 80% majority holder and a 20% minority holder, it's a different thing. And so in a lot of cases, you do want to bring in another attorney to represent one of the sides.
The same with financing. The owners may be interested in getting a venture capital company interested. They may have some private investors, but there's lots of rules and regulations before you can move in that direction. Can you comment on that?
Yeah, definitely. There are lots of securities regulations. So the SEC is the federal agency that has federal securities regulations. There's also state blue sky laws. So you don't have to just make sure you're in compliance with the federal regulations. You also need to make sure you're in compliance with state regulations, and it becomes more complex when you are soliciting funds from out of state. So if you're in one state and you have an investor in another state, then you're touching on different states. And so, I advise, even myself, I'm a corporate attorney, and I do know a fair amount of securities laws. I still advise my clients to go seek the advice of a securities lawyer, because there are even criminal penalties involved if you get the stuff wrong. So you want to make sure you get it right. And there's various penalties, such as the investor being able to get their money back and so on and so forth.
Now, you mentioned to me that you have an office in both Beverly Hills and Minnesota, but our listeners here today are in Burnsville and Eagan. Can you tell us some information about any recent Minnesota law that might affect businesses or entrepreneurs?
Absolutely. So this is in regards to LLCs. Minnesota has enacted the Minnesota Revised Uniform Limited Liability Company Act.
That's a mouthful.
It is a mouthful, which is codified in Chapter 322C of the Minnesota statutes, and that is replacing Chapter 322B. So starting January 1st, 2018, all LLCs, no matter when they were organized, are going to be subject to the new law. And if you're forming a new LLC today, for example, it's already going to be subject to this new law. Without going into all the details of what the new law covers, it most affects companies that have multiple members and where those members have differing interest amounts. So we talked earlier a little bit about the majority interest holder versus the minority. Under the new law, unless you have an operating agreement that says otherwise, if you have a majority holder and a minority holder, voting is going to be per capita, which means each person gets one vote. It's not going to be that you get to vote in proportion to the interest that you hold.
Wow.
It's going to be equal. And similarly, distributions to the owners prior to termination of the LLC will also be equal. So if you're the majority interest holder, you're probably not going to like that. And it's a good idea to go see your attorney and see, if you need to draft up an operating agreement to reflect, your true intentions.
Got it. Well, that's actually a pretty important issue, and with the new changes in the law, I would think that any business that is an LLC would want to have their operating agreement looked at, right?
Yeah, definitely.
Now, tell me a little bit more about starting a business. Let's say I wanted to, there's a real shortage of electricians and contractors and carpenters. What if I wanted to create a business to coordinate getting these employees hired by companies? How would I go about doing that?
So first of all, you want to identify, so I did talk about the competitive advantage, and Warren Buffett famously coined the term moat, and that is really, what is your long-term competitive advantage going to be? And assuming you have thought through all this, and you've got this great plan in place, then you're going to want to think about what kind of structure you're going to have. And there are lots of different structures that are possible. So there's general partnerships, which can be formed just by 2 or more people acting as if they're in a partnership. There are C corporations. There are corporations that make an election to be taxed under subchapter S of Chapter 1 of the Internal Revenue Code. There are LLCs, as we talked about, and there are different varieties of partnerships. So we really have to think about, are you going to be in business by yourself? Are you going to have partners? I tell my clients, go speak with a tax professional, because the tax nuances are different for each of these entities. And they have different benefits, and they have different requirements. An S election, for example, so a corporation that makes the election to be treated as an S corp, you have to file that election within 2 months and 15 days of the first day of the taxable year that it's to take effect. Another limitation on that, though, is there can be only one class of stock issued. You can't have more than 75 shareholders. So it's probably fine for your electrician example. It still sounds like it's going to be more of a smaller company. That'd probably be fine. But if you have a company that's going to be really big, oftentimes we see those, again, that grand idea of taking it public or raising venture capital money to be C corporations. So lots of things to think through. The benefits also, of forming an entity as opposed to one just naturally occurring like a sole proprietorship or a general partnership, is the limited liability protection. So
Right. That was my next question,
Okay.
in fact, is if you form this corporation, LLC, or what have you, can your creditors come after you personally?
Okay, so the advantage of the LLC, of the corporation, and even certain partnerships, to the extent you're a limited partner, is limited liability protection, but it's not absolute. So in Minnesota, there's a seminal case called Victoria Elevator.
Sure.
And the court lists several factors that need to be met. And if they're not met, this is what the court looks like to determine if the veil can be pierced.
Right.
And that's when creditors can come back and hold the owners personally liable. And there's several factors, but those include undercapitalization of the company, absence of records, corporate records, and failure to uphold corporate formalities. Commingling of funds is a big one. So
Absolutely.
You need to make sure that you have a separate bank account for your business, a separate account for your personal. You're not commingling those. It's a very important thing, because the last thing you want is for someone to pierce the corporate veil. But also in these cases, there is an element of injustice. Usually we see when the courts do allow the veil to be pierced. And so the courts, they're not going to allow you to just form a corporation so you can defraud people. That's not the purpose of the corporation. They're not going to allow it to happen.
And let's say that you form this corporation and it fails. A lot of companies do. Do you provide advice as to how to dissolve the company?
Yeah, certainly I do. And if it does get to be, a very complex area, then, where there's bankruptcy might be an issue or something like that, then we do bring in other experts to help.
Tell us about some of your experience in the law and what you enjoy the most about it.
So my most favorite thing to do is to create value for folks, and that comes as a business advisor, and that also comes when I help people resolve their disputes outside of court.
Right. Tell us about business dispute resolution.
Yeah, I'd love to. So as I mentioned, I was a litigator and trial attorney before. And so I had a firsthand viewpoint of litigants who would go through this very long and expensive and frustrating ordeal of trying to get justice. At the end of this long road, we found that justice, was rarely ever had because our justice system is imperfect. You need to hire attorneys, you have to pay them, there's a process it has to go through. And so you have a pie and it's being chipped away, and the longer the time is passing, the less pie there is to distribute. So I find enormous pleasure in helping disputants get to a resolution more quickly and less expensively, and just helping them even salvage relationships at the end of it.
And that's got to be a little awkward if they're upset with each other. Do you try and mediate the dispute, or do you end up representing one side or the other?
I do mediation. More often you'll see me acting as an advocate for one side. And I think it's really important to validate your client's emotions because they're very emotional. Everyone's emotional. And especially in businesses, if it's a business partner that you have a dispute with, that was someone you trusted, someone you spent a lot of time with. So I want to validate their emotions, yet at the same time, I want them to be realistic about the costs of litigation, and also, maybe broaden their perspective, because we're really good at seeing things through our own eyes, through our own perspective. But it does take, the role of the attorney is to help the client see the big picture and the legal ramifications of different decisions.
I so agree with you, and I think that communication is the key. And when I see businesses run into disputes among owners, it's often that communication or lack of trust. And you get stories from different people that are completely opposite, and they both saw and said the same thing.
It's true. Trust is very hard to rebuild once it's been broken. Part of the problem is a lack of communication, as you mentioned, up front. A lack of a dialogue between the owners and having them voice their expectations. You shouldn't assume that the other person has the same expectations as you do. And that's why it's important at the outset, like I said, you want to draft that operating agreement, that buy-sell agreement, while you're still friendly and on good terms, while you can negotiate it, because once things have gone sour, it becomes very difficult to be cooperative at that point.
And so in that operating agreement, you may want to have clauses that explain what's going to happen if there is a termination. And
yeah,
maybe
absolutely.
What kind of ideas would you suggest?
How you're going to value the company. So, oftentimes one person is going to need to leave the company because they just can't get along anymore. But then the big question comes, well, how much money are they going to get paid to leave the company? What is the company worth? And people can have wildly different ideas about that. So you do want a mechanism in place to value the company.
What do you think about 50-50 ownership of a business?
I don't think it's a good idea.
I don't either.
I think it's a way to cause deadlock between the owners, and it's not fun to be the minority shareholder by any means. But at least if you have a mechanism in place for resolving that disagreement, it's a better idea.
Well, I couldn't agree with you more. I think I've represented a lot of people who want to form this 50-50 business deal, and I just warn them that they may get into arguments about every aspect of the business, from where they bank to their employees to their where they want to have their office, to just up. And if it's 50-50, what's going to happen if they continue to disagree about each and every aspect?
Then you're not getting any business done, right? Then you're just arguing the entire time. And as a business owner yourself too, and having represented companies, that there are thousands of decisions to be made. It's not just one or two. There are daily decisions that have to be made.
Now, you've been practicing law for about 10 years, and you've seen a lot of changes in business and technology in the last 10 years. In fact, you own a tech company. So why don't you just tell us a little bit in your own words what these changes are that you see?
Thank you. Yeah, I co-founded a tech company with my brother, and it's in the predictive analytics realm. We do predictive analytics for apps. So we help provide marketing recommendations and product optimization recommendations to drive and maximize return on investment and lifetime value. And so that's been fun being in the tech industry. But really over the last 10 years, business has evolved tremendously. Marketing has evolved tremendously, and the marketplace has evolved tremendously. So from the marketing standpoint, we have marketing has become very inexpensive in a way because there's lots of different social media platforms, and it's easy to get your message out. It's also become very scientific. You can now target a specific audience, and you can deliver your message to the exact people you want to hear it. And you can measure the effectiveness of your message. Actually, that's part of what our company does. On the other hand, because it's become so easy, there's a lot of noise, and people are tired of being sold to all day. And there's a lot of spam, and you really have to be creative to differentiate yourself and make sure your message is going through, and that's where the science comes in and the predictive analytics. So it really behooves one to get ahead of that and know what tools are out there. In terms of the marketplace, people are now shopping online like never before. You can buy your groceries with an app and have it delivered to your house in 2 hours. People turn to Amazon, to eBay, to Etsy, to all different kinds of websites to purchase their consumer goods. And even services, even my own law practice, in many ways, is a virtual law practice. I have clients across the state, across the country, and across the world, even whom I've never met, who I do business with. And I can travel and do business because of a mobile device, because of a cell phone, because there's Wi-Fi everywhere we go. And that's really a big way in which business has changed. Another thing that we see now is these disruptive companies. You see it in the lodging industry with Airbnb, and you see it in the transportation industry with Uber and Lyft. And these companies have figured out how to leverage the resources of everyday people. So instead of having to make a massive investment in operating expenses and assets, they are now tapping into the homes and the cars and the resources of people to scale their company and reap huge profits.
And that's going to just get bigger and bigger.
It is, and it's very important. That's why I said at the beginning, you need to have a business plan, you need to have a moat, your competitive advantage, and you need to be able to protect it. And you really need to know, you have to be on the cutting edge of technology just to keep up.
Can law keep up with technology? Because in order to ultimately resolve your dispute, you have a right to a jury trial. And while you are certainly promoting the resolution of business conflicts through mediation and resolution, somebody could be very stubborn and just decide they want a jury trial.
Oh, that's absolutely true. You can't resolve everything because there are many people that are either unreasonable or at least behaving unreasonably or at least very emotional with respect to a certain conflict. And then, as you mentioned, now that we're in this era of doing business, cross state lines, jury trials are an issue. So, it's important in your contracts to make sure you have that choice of law and venue provision, or else you may find yourself in court in a different state that you are not, wanting to be in.
I've advised a lot of clients over the years on their credit applications to have personal guarantees and to have a venue clause allowing any lawsuit to take place in the county where my client resides. And then I also advise them to think about whether they want to have a clause that any disputes get resolved through some type of arbitration process.
Or mediation, or at least try to go to mediation before you do go to litigation.
In your role as both an attorney and as a resolution dispute person, how do you arrive at keeping a reasonable fee and how do you negotiate that with your clients?
Well, I think that you always have to keep the best interest of the client in mind. And I've actually written about this on LinkedIn, and it's a big platform of mine, that you are not acting in the best interest of your client if they are spending more in attorney's fees than the resolution is worth. And, like I said, we don't have a perfect justice system. You need to explain to your client ahead of time what they can expect. How much is it going to cost to pursue their resolution, and what can they really expect to achieve from it? And I always tell my clients, if I don't think that it's going to be a good idea to pursue because it's just too expensive, I tell them, I don't think you should pursue this. As a business person, the reaction is, I'd love to take your money. But as your attorney representing your best interests, I don't want to.
Right. But isn't there an inherent conflict of interest for an attorney who needs to get paid in order to make a living, and yet they also want to advise their client of how to keep their legal fees as low as possible?
That's a valid point, and especially in litigation, there's a much bigger conflict, because as long as the conflict persists, the attorney's getting paid. My viewpoint is there's enough conflict out there to sustain a good business for me. So I definitely don't want to be adding to that fire.
Right. Do you have any stories that you can share with us about businesses without naming names and violating attorney-client privilege, but just to give us a general idea?
I've got, a couple different heated disputes right now that's going on, and, just negotiations taking longer than you'd hope for. At the outset, you hope that you can see the big picture, and I can resolve this and create value for all parties, but it's just difficult, like I said, when people are emotional, to be able to do that. I did have one interesting case, which I'll share. Actually, it was my very first trial out of law school as a first-year lawyer. I represented a client on a breach of contract case against his ex-wife and ex-mother-in-law, and it was really kind of a crazy case. We got a great verdict in our favor, but you really do see all different kinds.
I can imagine. Well, it's been a pleasure talking to you about the business law and about entrepreneurship, business dispute resolutions. Any final thoughts or comments before we wrap this up?
Yeah, thank you for the opportunity. I do want to tell folks listening out there, I want to encourage you to start your own business if you have the opportunity, if you have that vision, because it's tremendously rewarding. Not only is it good for the economy, you're stimulating the economy, hopefully creating jobs, you're providing something of value through your goods or services to consumers who really want what you have to offer. You have the ability to work your own schedule and be creative. So if you have that idea, I encourage you to go out there. And I also, lastly want to mention that it is very important to conduct yourselves ethically, and don't sacrifice, long-term gains for short-term gains, and do consider any negative externalities that might result from your business.
Well, thanks so much, Ellie. I really appreciate it.
Thank you so much, Bill. It's been a pleasure. Thank you.
Thank you.